Hey guys, welcome to today's Legal 101. It is the last one of the week until next Thursday, like I intimated on Monday. And it's a Wednesday, so it's on family and succession law. I want to give a shout out to one of my colleagues, Priyanka. I bumped off a lot of the ideas I was having throughout my preparation for this Legal 101 with her. Thank you. And let's begin. Now, in the famous words of Justice Mrima in a 2016 judgment, there are only two types of gifts in law. Those are gifts made between living persons and gifts made in contemplation of death. Gifts made between living persons we will talk about in a later video, but today we are talking about gifts made in contemplation of death. A gift made by a person during their lifetime in contemplation of their imminent death is a description of a gift made in contemplation of death. Okay? The gift is valid even if there is no transfer of legal title. But there has to be certain thresholds to be met before somebody can be able to say, I have a valid gift that I received in contemplation of somebody else's death. All of them must be met. All of them. They are provided under Section 31 of the Law of Succession Act. Number 1, the person making the gift must, at the time of making that gift, contemplate the possibility of their death, whether or not expecting that death, as a result of a present illness or imminent danger. The danger must be imminent, the illness must be present. Okay? You can't purport to have received a gift from somebody who made that declaration in 2009 when we are in 2012, for instance. Okay, it's what Justice Nyaundi said in a 2018 decision. The death has to come out of a present illness or imminent danger. Number 2, the person making the gift must deliver to the intended beneficiary possession or means of possession of the property or documents or other evidence of title over that property. For example, if it's a car, do you have the key? If it's a house, do you have permission to perhaps fence it off? Okay? Something that shows you have means of possession of that property. Number 3, the person making the gift has to make that gift in circumstances to show that he or she intends it to revert to him or her if they survive the illness or danger. Number 4, the person making the gift dies from any cause without surviving the illness or danger. Number 5, the intended beneficiary survives the person making the gift. And lastly, a person gives movable property, which includes any debt secured upon movable or immovable property, which property he could otherwise dispose by will. This particular element we will exploit in a later video. Now, take an example of this case. Justice Korir gave a decision in 2017. Where the fact was that somebody named Kwena, who had been seriously sick, succumbed to his illness. A few months before his death, he had gifted the land to the respondent in that case. There were witnesses to Kwena's proclamation. They even testified, but there was nothing to show that there was delivery of possession or the means of possessing this land to the respondent. And like I've said, all the elements must be met. Lastly, a gift in contemplation of death cannot be valid if the person making the gift, number 1, passes away by suicide, number 2, lawfully requests its return before he passes away. Okay? So we will explore other areas of this issue of gifting. We will talk about whether or not it is possible as a dependent to this deceased person to challenge a gift given under Section 31 of the Law of Succession Act. Okay, that marks the end of today's Legal 101. See you next week. Please, if you reach out to me in the DMs, perhaps in the next couple of days, perhaps in the next 5 business days, and I'm unable to respond, please bear with me. Like I said, on Monday I have I have other commitments that are going to take up so much of my time. I might not be able to get into the DMs. But thank you so far to everybody who has reached out to the legal questions, seeking clarification, etc. I'm available to help. Sawa. Bye.